The second matter on the docket today is U.S. Bank and Doepker. Did I pronounce that correctly? Doepker?
I believe so, Judge.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Allison Murat, and I'm here today on behalf of the appellant, U.S. Bank. I would like to reserve 5 minutes for rebuttal. This case involves a residential mortgage foreclosure that was decided at the summary judgment phase in favor of the borrowers based on language in the paragraph 22 notice. The borrowers argued at the summary judgment hearing that the notice was defective because it failed to comply with paragraph 22 subsection B. The trial court agreed, granted summary judgment, and dismissed the case. The standard of review in this appeal is de novo, and the standard to be applied to the sufficiency of the paragraph 22 notice is substantial compliance. This court adopted the substantial compliance standard in Greentree v. Milam. Now, the Milam decision did not exist at the time of the summary judgment hearing in this case. Milam was issued in 2015. The summary judgment hearing here was in 2014. So the parties and the trial court did not have the benefit of Milam at the time of the hearing. And while they did not have the benefit of Milam at that hearing, the law as it exists today is the law that should be applied in this appeal. After Milam, the other district courts of appeals also adopted the substantial compliance standard, and there are several decisions now discussing language similar to the language that's at issue in this case. There are two cases in the third district, Cadet and Garcia, that involve language that's very similar to the language at issue here, and the third district said that that language substantially complies.
Can I ask you a question first, procedurally, because it was Mr. Stopa filed both a motion to dismiss and a motion for summary judgment in the same pleading. You would agree they both have different standards?
Yes, Your Honor.
One is the sufficiency of the pleadings under 1.110.
Correct.
And the other is 1.510.
Correct.
As to whether there is a genuine issue of material fact.
Correct.
So they're two very different motions, are they not?
Yes, they are. Nevertheless,
It appears that the trial court granted the summary judgment and even said on the record this isn't a motion to dismiss, but we're talking about a condition precedent, aren't we?
Yes, Your Honor, we are. And we're talking about whether or not the language within this breach letter sufficiently complied with paragraph 22. So, yes, the borrowers did file a motion to dismiss and a motion for summary judgment. There was a hearing, and the court treated it as a summary judgment, and then there was an order entered granting the summary judgment, I believe, but also dismissing the case without prejudice.
Well, there were affidavits that you mailed it and affidavits that they didn't receive it. So
Yes.
There seemed to be an issue of fact.
Yes, Your Honor.
As to whether it was sent.
I don't know if there was an issue of fact because there is a case now in the 5th District, I believe it's the Roman case, that even if the borrowers file an affidavit claiming that they did not receive the notice, that does not create an issue of fact when there's an affidavit from the bank saying that the notice was sent via first-class mail, which is what is required under the mortgage. And I'm sorry I don't have a citation.
We have the Ostrander case out of our district.
A recent case, yes, Ostrander also said that the language in the affidavits in Ostrander is identical to the language in the affidavits in this case.
Okay,
And
so below, Judge Rondolino found as a matter of law that this letter was insufficient.
Yes, Your Honor. And there's no indication that the trial court judge applied a substantial compliance analysis at the hearing, and that's likely because the Milam decision had not yet issued. There was some confusion prior to Milam, and I believe that Milam resolved that issue. Now, we would submit that the letter here more than substantially complies, but at the very least, it at least substantially complies. And again, there's the...
Is that necessary for us to determine in this appeal?
Your Honor, you would only need to determine if the letter substantially complies.
Why would we have to do that?
The
The issue that you're raising is that the trial court applied an incorrect legal standard, that is, did not apply substantial compliance.
why would we not merely reverse it back and allow the trial court to apply the correct legal standard and allow the appellees to raise whatever arguments they have about whether there is substantial compliance or whether there was some prejudice that flowed? Why would we have to determine in this appeal whether or not this letter is in fact substantial compliance if the trial courts never got there?
I understand, Your Honor, and it would be proper for you to reverse and to allow the court to apply the correct legal standard since it was not clarified at the time of this hearing and there is now intervening law. However, I think because the standard of review here is de novo and Your Honors can look at the sufficiency of the evidence here and you can look at the language of the breach letter and make the determination as to whether or not it substantially complies or not, and then there would be no need to then have the court go through that again.
But if we follow your theory there, we deny the appellee due process to make legal arguments and factual determinations about whether this really is substantial compliance. They would have never had an opportunity to make those arguments, correct?
I understand your point, Your Honor. Yes. So if it is reversed and for the court to make the determination of substantial compliance, I believe that that would be proper and still be what the bank is also entitled to here because of the law that is now substantial compliance, and the bank would also be able to argue that same standard at the hearing. Now, if you look at back to the language of the letter here, though, that the issue that the court had is because the letter required the borrower to pay certain sums that were past due. I believe it was $83,000, in addition to any additional payments that come due between the date of the letter and the cure date. And the letter was sent January 7th. The cure date is February 6th. So there would be
monthly payments that are required by the loan obligation would be readily determinable. But the letter also talks about fees and other charges may continue to be assessed. There may be other fees, escrow advances or corporate advances. Presumably there might even be attorney's fees that would be chargeable to the borrower. How can the borrower determine based on this letter what amount is required to cure?
So I believe that you're looking at the second page of the breach letter. In the first paragraph, it says that if additional payments become due, those payments are required to be added to the cure amount. The second part of that paragraph says that other fees may be incurred by the lender, but those fees are not required to be added to the cure amount. And then in the end of that paragraph, it says to obtain the amount to bring the loan current, please contact SPS at this number, and SPS is the loan servicer.
Of course, a letter of acceleration is supposed to tell the borrower what they need to do to cure their, well, let me phrase it differently. Would it be acceptable to send a notice letter that says you're in default, you haven't paid the payment due such and such, call us for an exact payoff amount or a reinstatement amount, and if you don't, then we can sue?
Your Honor, I believe that that letter would be acceptable, and I think that letter, I know that a letter like that was accepted by the 5th District Court of Appeal in the Astoria case, and I did ask the court to take judicial notice of the trial court order in that case that memorialized the language in that letter, and that was exactly what the letter said. You are in default. Please call us at this number to obtain the amount required to cure. And that would be the action required to cure, which is what the mortgage dictates, is to describe or to specify the action required to cure, which is a process. It doesn't say that you have to delineate the sum that's required to cure. So when you're looking at this from substantial compliance, if you want an exact amount, that would be precision. But here, it says additional payments may become due. That would be within the personal knowledge of the borrower. And there's also a phone number here to call to obtain the amount, and that same phone number is listed 4 times in the letter. And there's no summary judgment evidence from the borrower to suggest...
So a letter that says, I know it wouldn't be worded this way, but the letter doesn't say what amount is required. It just says, not in this case, but in the hypothetical, that in order to cure the default, call us and we'll tell you what's required. That your contention is that would be adequate.
I submit that that would be adequate.
So isn't that under the acceleration language of the mortgage adding 2 steps rather than 1 step? Because paragraph 22 says the notice shall specify the action required to cure the default. So giving someone a phone number and they call that number, that doesn't cure the default.
I think the action required to cure is
It doesn't say
calling the
actions or
phone number
steps.
and obtaining the amount and then paying that sum. So it says,
So what you're saying is it is acceptable to impose a 2 or 3 or 4-step requirement on a borrower, and that would be sufficient to comply with the notice shall specify the action required to cure.
I think that if there was a 2, 3, or 4-step process, or steps,
Giving a
it would be all
telephone
part
number,
of this
giving
same
a
process.
telephone number at least adds 1 step, right?
Correct. Well, it says that you need to pay this amount in addition to any additional amounts that become due, and
Well, I know what your notice is, but you've now given us another DCA's case where potentially it doesn't even require that an amount be specified. I mean, you just argued that. So let's take that hypothetical because we have to consider how this will impact other cases.
correct.
So using that hypothetical, your position seems to be that as long as the borrower is given a number to call, that is a notice which specifies the action required to cure the default.
I think that there would need to be more than perhaps just call us, like there is in this letter. I think that it's clear that you're in default $83,000, you need to pay this amount. If your monthly payment becomes due between the date of the letter and the cure date, you also need to add that to the amount required to cure. And to obtain that amount, which you need to pay, please call us to get that amount. So it's not just, hey, you're in default, call us. Here, there's a little more specificity. So I think it would have to be on a case-by-case basis. I don't think that there would be a blanket determination that a phone number would be sufficient.
Well, let's assume I agree with you. I want to go back to Judge Casanueva's question as far as what happens next. Would it be appropriate to remand because the borrower might be entitled to put on some evidence that in fact they called the number and they couldn't get through? I mean, I don't know what happened in this case. We don't have that information, but we do know there are cases out there where borrowers claim they call, they get into a phone tree, and they can never get the information. So is that something that would be an evidentiary determination on remand should the borrower wish to raise that?
That would be a fact issue that the court then would require a trial, I believe. If the borrower is going to contend that they called, then the bank has the opportunity to show whether or not they had received a phone call. And again,
But for purposes of substantial compliance, there is a potential prejudice analysis that has to be made, correct?
I think that you can make the substantial compliance analysis perhaps separate from a prejudice analysis, but the prejudice may be part of the analysis like it was in some of the 50 DCA decisions in Gorell and in the
Doesn't
Johnson.
Judge Solario's opinion for the court in Milan talk about at least one section, the phrase of prejudice?
In a footnote, yes, Judge Solario does address prejudice and say that it arises from the insurance context. And here, we did discuss prejudice in our briefs. However, I think that you could make the determinant of substantial compliance separate and apart from prejudice. However, I do think if you're talking about substantial compliance, Judge Solario also said that substantial compliance is, in essence, the opposite of a material breach. And part of a material breach could be considering whether there was any prejudice or not to.
And again, I want to go back to the hypothetical we were discussing a few moments ago. If a notice letter doesn't have as much information as this letter has in it in terms of dollar amounts and whatnot, but it gives the number. It says you're in default, you didn't pay the payment due December 1, 2014. Call this number and we'll give you the amount, the exact amount to reinstate, and you've got to do this within 30 days or else. Your argument seems to be that potentially is substantial compliance, and the borrower contends, no, that's not substantial because the notice didn't specify everything that we had to have in order to cure. And by the way, we tried to get that information and we couldn't get through the phone tree. And so where does the substantial compliance argument and the sufficiency of the letter argument that it should be a de novo, look at the piece of paper and determine that's enough, it seems to leave out potentially one aspect, which is the reality of were they put on notice as to how the default must be cured.
I agree with you there, Your Honor. I agree that there could be more to the analysis, and
So if we reverse, do you concede that if we reverse on the facts that we have before us, that it would be best to let the trial court apply the correct standard and allow the other side to raise what they're going to raise? Or is it still your position that as a matter of de novo review, we can say, this letter is good enough, you're done?
I understand the points that Your Honor has made. However, I do not want to concede the point. I think that Your Honors can make the determination as a matter of law that this letter substantially complies. And I'd also like just to divert back to the Milam decision in this district. I did give you the...
You're at 15.
Yes, Your Honor, thank you. I gave you the Astoria case out of the second, but back to the Milam case. In that case, that letter also required that the additional monthly payment be paid, and a specific amount was not denominated in that letter. And I think it's a very similar letter to this letter, and Judge Solario in that case did hold that the letter substantially complied. And if Your Honors don't have any more questions, I will save the remainder of my argument for rebuttal.
Mark Doepker for the appellee. Seated with me at counsel table is Latasha Scott. You'll see her co-counseling with me on some of these files.
Mr. Stopa, before you begin, you sent us a supplemental authority yesterday.
I did, Judge.
Sir, it doesn't comply with the rules. The rules require that you identify the issue that the case law applies to. And I would point out these are 1981 cases, 1982, 2001. The latest you have is 2011. Why is this supplemental authority?
Well, Judge, after I briefed my answer brief the first time, I came across in a similar context on a different appeal additional cases on the issue of preservation in the summary judgment context. There aren't any out there. I apologize, I didn't find them the first time, but I found those after I had done the initial brief and wanted to make sure that the court was aware of the cases on preservation in the summary judgment context. As I indicated, there aren't many, but the Florida Supreme Court did rule on that issue in Doepker, and this court did in Hunter, and I wanted to make sure the court was aware of those.
Well, you also filed a motion to dismiss and a motion for summary judgment, and it seemed to me from the transcript you were arguing the sufficiency of the letter from a motion to dismiss standpoint that it was a failure to comply with the condition precedent, but yet the court granted the summary judgment. You didn't argue the summary judgment standard. You didn't argue there wasn't any genuine issue of material facts, so
Judge, with all due respect, the procedural issue that you're raising is a non-starter. They're not even arguing that, my opponents. We did argue the summary judgment portion of the motion because that's what allowed me to argue the content of the letter, which was attached to their affidavit, which you obviously can't do at the motion to dismiss. I argued then, and I'm arguing now, that there were no genuine issues of material fact because even if the notice attached to their letter had been sent, it did not contain the information that paragraph 22 required, so we were entitled to summary judgment.
okay, so that begs the question then that was raised here, because there's a Morton case where Milam was not, hadn't been decided, and we reversed and remanded for the court to apply the substantial compliance analysis. Are you saying to us that we can de novo, under a de novo review on our own, decide whether this is substantially compliant or not without a remand?
I think that you could look at this letter and determine that it does not substantially comply on its face under a de novo review. I do not think that you could look at this letter and conclude that it does substantially comply without a remand because, as Morton indicates, there may be additional facts that could be adduced at an evidentiary hearing which could show this does not substantially comply. So I think you could look at the face of the letter and conclude it does not substantially comply, but I don't think you could look at it and say that it does substantially comply without additional evidence in light of Morton. So,
for instance, just give me an idea of additional evidence.
But as Judge Silberman was indicating, the additional evidence might show hypothetically that my clients had called 20 times and repeatedly called to try to ascertain the amounts due, and nobody could tell them the amount that was necessary to cure the default. And they had the money ready, willing, and able, and were ready to pay, but nobody could tell them the correct amount to pay. I mean, to use an extreme hypothetical, if those facts were adduced, then I think that that would very much support an argument that the letter did not substantially comply. But I also think, and what I ask in the brief, is that Your Honors can look at this and conclude that it does not substantially comply But before I even get to that, I want to start out with what happened below, because my opponent really didn't touch on this at all. What happened below is my opponent's trial counsel admitted that sentence is a little confusing on page 176 of the record. And my opponent below said nothing about substantial compliance, nothing about prejudice, nothing. So here they come to this court and ask you to reverse based on substantial compliance and prejudice when they said nothing about those issues below. In Hunter, this court ruled a party may not raise an issue for the first time on appeal from summary judgment, following the Florida Supreme Court in Doepker. That's what they're doing here, is they're asking you to employ a substantial compliance analysis that they didn't even ask for below. In other words, the lower court couldn't have gotten it wrong by not employing a substantial compliance analysis when they didn't even ask for it.
Well, you told the court not to because Judge Rondolino was the first one on page 174 to ask you if substantial compliance applied, and you said no. I don't think substantial compliance is an issue to talk about. So substantial compliance was raised below.
Not by them, Judge.
Plus, but you're asking us to disregard the prevailing law.
Judge, I'm asking you to I'd ask Your Honor, read the concluding paragraph in King. What does that concluding paragraph say? It says, and I have it here, it is difficult to overemphasize the importance, absent fundamental error, of preserving issues and arguments before asking an appellate court to reverse. The importance of this principle is too often not appreciated, and appellate courts are constrained, as we are here, to affirm orders which might otherwise have been reversed. That's the principle of law that you should be following from the Florida Supreme Court on this first issue in my answer brief. The lower court didn't get it wrong based on arguments they didn't raise. They didn't even mention the concept of prejudice, not even mentioned. It wasn't mentioned by anyone. They didn't argue for a substantial compliance analysis. In other words, Judge, when Judge Rondolino and I talked about substantial compliance not being the standard, that was their time to come in and say, yes, I think substantial compliance is what you should be applying here. And Your Honors, nobody's argued this issue more than me. Before Malam, there were a lot of trial counsels were asking for a substantial compliance analysis. A lot of them weren't. This trial counsel did not ask for a substantial compliance analysis. You don't get to come to the appellate court and ask for a standard or an argument or a legal theory that was not advanced below. That's clear failure to preserve. So I submit that an affirmance on that basis alone is appropriate. I also submit that we should prevail on the merits, and here's what I think is the dispositive distinction that I have, in my mind, learned over a period of time that I think that the case law supports. And that is, I think that you should be able to look at this letter, a consumer, using the term from Malam, a reasonable reader, a reasonable consumer should be able to look at a 22 letter and should be able to ascertain what it is that they're supposed to pay in order to cure the default. That is the entire point of paragraph 22. It inures to the benefit of a consumer, drafted by the lender in boldface font, to give them a chance to fix the problem before they get sued. You should be able to pick up the letter and tell what it is you're supposed to do. Now, Malam and other cases make clear that you can pick up the letter and the loan documents, okay? And what's the fact pattern in Malam? In Malam, the letter required additional payments after the date of the letter, but it was only the next month's payment. And so in that case, the amounts that were due were amounts that were readily ascertainable to the borrower because they know what they had to pay under the terms of their own note and mortgage, right? It wasn't an amount that you couldn't ascertain by looking at the letter and the loan documents. That is the dispositive distinction.
But Malam says the purpose of the clause to specify the action required to cure the default is to ensure the borrower is informed of the lender's determination of what a borrower must do to bring the loan out of default. Here you have in bold, action required to cure the default. You must pay $83,000 together with payments that may subsequently accrue. Well, you would agree that anything that accrues, they're contractually obligated to pay. This is an installment loan.
Okay, but
but also the action required to cure the default tells them they must pay $83,000. It tells them they must pay this. Now, the language that you have problems with is all with the word may. You may but these amounts are not required to cure the payment default. You'll still owe them. So how does this not tell the Doepkers that if I pay $83,638.47, they will not foreclose?
Judge, my problem is with much more than the issue, the word may. The letter's dated January 7th, okay? And it doesn't say pay $83,000 to cure the default. It says amount required as of January 7th to cure the default is that $83,000.
But
Well,
that's the nature of this agreement. It is an installment contract. If I send you something on January 7th, it's going to reach you in a few days, and I'm going to tell you that if you delay, the February payment may come due, and you're going to be owed that.
Exactly. But the letter doesn't say you have to pay the February payment too. It's not limited to the installments. That's the dispositive distinction.
You've argued in the past, if I remember correctly, that actually requiring or including the next month's payment would be a violation of the contract, that in fact you're entitled to cure as a borrower what is then in default. And if you don't make let's say it's a December 1 payment, and you don't include the January 1 payment, and you've cured on January 1 or January 2. Actually, I've got to change the dates. December 15th default, you have a January 1 payment coming due, you cure it on January 5th. So the payment is due, but isn't really in default yet. And your position has been, and I assume you want to stay consistent with that is a separate event of default. If it's not paid, you cannot require the next month's payment to cure the current default.
I believe that is what the law should be, based on the Florida Supreme Court and Singleton-Graymar and the nature of an installment contract, that the next month's payment can't be required to cure this default because it's a separate default as a matter of law. I think that's what the Florida Supreme Court also says in Bartram, but this court in Malam didn't agree on that issue. So I don't suspect your honors are going to disagree with what Malam said on that issue, which is why I'm presenting the issue as the dispositive distinction, is this letter is not merely requiring the next month's payment in order to cure this default. And that's where I disagree with the way Judge Sleet is characterizing the letter, respectfully, in that the paragraph here that's dispositive requires these unspecified payments. It's not limited to the next month's payment. You look at this and you can't tell what they're requiring in addition to that $83,000 and change. You can't tell.
It doesn't require you to pay the additional
It does,
payments.
Judge.
It says they may become due.
Judge.
If you wish to cure it, you should add them to the amount required to cure.
Right.
How does this not say if I pay $83,638.47, they won't foreclose?
Because, Judge, it says amount required as of January 7th to cure the default. That's in bold, in capital letters. You read that in conjunction with the next paragraph, and it's very clear that that $83,000 is not what is required to cure the default. It's very clear that additional payments have to be included with that. And it's not just the next month's payment either, or the next month's late charge. It's unspecified payments that they don't tell you what they are.
And I know you make hay about the difference between bringing the loan current and curing the default, but I doubt a layperson knows the difference between that. But they do have here, to obtain the amount required to bring the loan current, please contact us at the 1-800 number. The 1-800 number is repeated throughout this letter. Why isn't that enough when they've given them what they believe should be done? U.S. Bank believes this should be done, and it's detailed. And then they give you a number. If you're confused, call us.
Several reasons. One, they don't say that calling is what you can do to ascertain the amount necessary to cure the default. It says to get current. Those are different things under the law. That's very clear. Several reasons.
How could a lender specifically itemize? Of course, paragraph 22 doesn't require you to give the amount. It just says the action required to cure the default. It doesn't say the amount. In the case law, it says you have to give the exact amount. But they've given you the amounts. Mortgages are moving targets. They continue to accrue. The payments continue to accrue. So how in the world can a lender give you exactly what you're supposed to pay in 30 days?
The way that 99% of lenders with 99% of these letters do? Most of these letters are not moving targets, Judge.
You wouldn't be in this courtroom if 99% of the lenders did that.
Absolutely, I would be, Judge. That's how most of these letters work. You pick up most of these letters. They aren't a moving target. When's the last time you've seen me here on this issue, on this amounts issue? The Malam issue cures 99% of these arguments. That's why the dispositive distinction, which you don't see in most of these letters, is to simply say where the letter requires you to cure the default additional payments that are not just the next month's payment, but these additional unspecified nebulous amounts. That's not what's required, and the phone call doesn't fix that issue because there's no DCA decision that says that it does, because paragraph 22 doesn't contemplate that, because the 3rd District in Midtown says you're not supposed to be a detective in order to ascertain the information that's required to be in a notice. My opponent relies on the Astoria case, but Judge, Your Honors, there's nothing in the 5th District's decision that says making a phone call is sufficient under paragraph 22. What my opponent is trying to do there is trying to improperly inject facts into the 5th District's decision, which you can't do. As a matter of Florida law, you're constrained to the facts within the 5th District's decision in Astoria. What they want you to do is to look to facts which are not contained in that decision in order to conclude that, well, there the Astoria court said that it was sufficient to make a phone call. If the 5th District wanted to say it was sufficient to make a phone call, they would have said so within the 4 corners of that decision. They didn't. What you can't do is piecemeal facts that are not in that written decision. There's lots of cases that make that clear. This court actually struck a brief where I argued this exact issue in a different appeal.
How is this letter different from the letter in the Garcia case from the 3rd? Wherein, hold on, you are in default for the total amount shown, $1,890.66, which includes mortgage payments, late charges, and any additional fees that may have accrued. Wow, that's vague. The amount of default will increase with an additional payment or an additional late charge becomes due. That's kind of vague. In order to reinstate the loan, please remit in guaranteed funds the total amount due, including any additional payments or late charges that become due, along with any fees for a market analysis or appraisal that will be ordered within the next few days. Of course, they don't give you the charge for that, but that was found to be substantially compliant by the 3rd DCA. How is this letter different?
Well, I think that this letter is different because from what I heard, Your Honor, reading there, those were the next month's payments and late charges in connection with the next month's payments.
It didn't say next month.
Well,
didn't say anything about a month. It
that's
said additional.
That's what I heard there, but I'd also note, okay, a couple things here. You're not bound by that decision. 2, it's time that we draw a line here, okay? It is very frustrating to have plaintiffs' counsel in these, lenders' counsel in these cases, and circuit court judges act like, based on Malam, and because there's never been a DCA decision that says a letter substantially complies, that substantial compliance is the end of the analysis. That's what you have right now. Substantial compliance, that's it. That's wrong. Substantial compliance is merely the beginning of the analysis. This court has clarified that not every letter substantially complies, and I think that's very axiomatic. But it's time that we draw a line and make clear that not every letter substantially complies. And on this fact pattern, where there is no DCA decision, I submit certainly not from one from this court that authorizes, that says a letter substantially complies when you pick it up and you can't tell what you're supposed to pay. Ask my opponent. I'd encourage your honors to ask my opponent on her rebuttal, how much are they supposed to pay based on this letter in order to cure the default? There won't be an answer to that. They're relegated to the phone call issue. And there's no DCA decision that says that you can pick up a phone and that cures the problem.
Well, it does seem that the paragraph that starts action required to cure the default, that says here's the amount, let me read exactly as it is. To cure the default, you must pay this amount as itemized below, together with payments which may subsequently accrue on or before the cure date listed below. And then it talks about the additional payments and then some other fees and so forth. But it does seem that it is readily understandable to mean that if you pay the $83,638 plus whatever monthly payments come due in the meantime, the monthly regular installment payment that is readily ascertainable, that will cure the current default. Now, I understand what you're saying, that, well, there are other things, and they say, well, maybe it won't, you might have to pay this, but you do have a number that you don't need to call a number to get. And then the next step in the process, which is not before us here, is whether a tender is required in some amount in order to say I tried to pay what they asked for and they didn't accept it.
I want to talk a little about prejudice. It sounds like that's part of what you're asking there.
Be quick, because you're at 18.
The prejudice concept emanates from the insurance context. There, prejudice emanates to the benefit of consumers because the insurance company drafted the contract for the consumer to comply with. So the court system says we're not going to give the behemoth financial institution that drafted the contract the benefit of getting out of this unless there was prejudice. Here, the roles are completely reversed. There's no reason to employ a prejudice analysis to the benefit of a financial institution that drafted its own contract to the detriment of consumers. Think about that from a consumer protection angle. The prejudice concept just doesn't make sense in this sort of context. I also submit respectfully that the reason the Fifth DCA employed the prejudice analysis was because borrowers were just winning too many of these cases. We don't have that problem anymore now that substantial compliance is the standard. You've gotten rid of that. So don't create bad law in the consumer protection context when you've already eliminated the problem by creating the substantial compliance standard in the first place. So, and also prejudice is presumed by the Florida Supreme Court in Macias when you have a notice that doesn't comply. So even if you went down a prejudice analysis, it's presumed under Florida Supreme Court precedent. So I submit you shouldn't, but even if you did, that prejudice analysis, prejudice is presumed as a matter of law. There's no tender that's required. There's no case that says the tender is required. The prejudice cases were limited to, it being off by one day when the suit wasn't brought until months later anyway, so it made no difference as a matter of law. But I think it's important that a line be drawn here in order to have these letters mean anything at all. When the judge is confused and the plaintiff's counsel admits that they're confused, that the letter's confusing, when they're the one arguing it and they admit that they're confused, I think that's a perfect illustration of how a reasonable reader, a reasonable consumer, can't pick this up and just know what they're supposed to do in order to cure the default, which is what 22 requires. So I submit that an affirmance is appropriate on the preservation grounds, because none of this was actually argued below, and on the merits as well. Thank you, Your Honors.
Your Honors, I'd like to make a few points.
Before you get to your points, I'm going to ask you if you can help me out with some of my points.
Yes, Your Honor.
I'd like to make sure that I'm in the right spot. In paragraph 22, the contract between you, your client, and the borrower says, lender shall give notice prior to acceleration following borrower's breach of any covenant or agreement. Is that correct?
May I?
Yeah, please get your paragraph 22 out. My question is this. It seems by operation of the word default, it means there has already been a breach. And the purpose of notifying the borrower is to say you have breached by failing to pay. Where does it say in paragraph 22 that you get to put in your demand, future unyet accrued payments have not been defaulted, but we can collect? If the purpose of a default is to say you have breached.
I don't think that the paragraph 22 doesn't say that you can include that language.
Well, it says, the notice shall specify the default. Well, the default has to be a breach that took place, right?
Correct, Your Honor.
That means that's a past action. Is that correct?
Correct.
So it's not a future action.
And
Doesn't your notice say that, if there's another default, you're going to have to give another notice? Isn't that why you're trying to put in future payments? Because you don't want to have to send another notice?
Well, here, there has been an uninterrupted default.
Well, take a look at your letter.
2010.
Your letter says it's dated January 7th, and the amount to cure is January 7th. So the minute you send out the letter, there's interest accruing before the time the person gets it, right?
Okay.
So you're going to say, pay us for the interest that's already accrued. Well, if the purpose of paragraph 22 is for a default, that's past conduct. How can then you vary the terms of your mortgage note and mortgage in your cure letter? Shouldn't you be required to follow the exact terms in your cure letter, which says the amounts due is $80,841. Any future payments may require a subsequent notice of default.
And I don't think that a subsequent notice of default would be required in this situation because
Why
the borrower...
not? Where is it in your contract that allows you to do this? Aren't you asking us to rewrite your contract to allow you to do this?
I don't agree with that, Your Honor.
It's your contract. What does it say in paragraph 22? That's what a default. That's past conduct, is it not?
Correct. And
That's not future conduct, is it?
This notice does specify the default, which was the
It's read in
amount...
contracts that says before acceleration. So it's clear that the language of paragraph 22 refers to a prior breach before a subsequent letter of acceleration. You're putting in your demand letter, by the way, something else may yet accrue that we'd like to collect for, so please call this number. My question is, that may make great business sense, but is that legally consistent with the contract?
I don't think it's something else that may accrue. From this letter and from the note in the mortgage, it's the normal monthly payment that is due under the note and mortgage on the first day of every month.
If they don't make that payment, is that a breach?
It would be a continual
And then before you
breach.
could accelerate, wouldn't you have to give notice?
Let me ask you a question, because you just said something that is troubling. You said a continual breach. The Supreme Court just came out with a case dealing with statute of limitations and dismissal of cases, where they said if a case is dismissed, everybody goes back to the beginning and the borrower can make its installment payments. So the Supreme Court seems to be suggesting that this isn't a continual breach, that each month is a separate potential default event.
Let me revise what I said as far as a continual breach. I'm aware of the law there. Here, it would be an uninterrupted breach. And that same language, I believe, is used in the Milam case in one of the footnotes, where the court says that it's not improper to to remind the borrower or to inform the borrower that they must make their current monthly payment when there's been an uninterrupted breach. Here, the borrower is already in breach.
The point seems to be that, one, you may or may not want to tell them that as a matter of good business, but the borrower isn't in default for the February 1 payment until February 2, 3, 4, 5, whatever the grace period is. So to say that in order to cure the breach and remain out of default, you need to pay any payments that come due during the interim, that seems to go beyond what both the contract and the law require. They're not in default. You can't give them an advance notice of default, right?
I believe when there has already been a default, like there is in this case, that there is nothing wrong with informing the borrower that they must pay that current month payment to cure. If you didn't put the language in the letter
To remain current.
to remain current, if you
After the cure.
correct, if you
There's
did,
a difference.
if you don't include this language in this letter,
They'll be
it might,
default again.
it may mislead the borrower into believing that they don't have to pay. This letter
So
says
you're doing this for the favor of the borrower. You're being good to the borrower.
it serves a couple purposes here. If
I mean, it makes perfect sense to me that you would tell the borrower, by the way, if you cure this breach, but you don't pay the next payment, you're going to be in default again. That's different than saying you need to pay not only what you're in default on now currently, but what is going to come up in the future.
when you're already in default, in this case for 4 years, and you don't require them to pay that upcoming payment as part of the action required to cure, should they choose to cure after that payment becomes due, if they pay it
They don't
prior
have
to that,
They don't have to pay. They don't have to pay it. They can go in default yet again.
and then it would allow them to
Perpetually be in default.
perpetually be in default.
It is your contract, your client wrote it. And my question is this action required to cure default? It says in that section of your letter, together with payments which may subsequently accrue. They haven't been in default yet, so how can you give them notice to cure something that hasn't yet happened and be in compliance with your paragraph 22, which is supposed to be to cure an existing default? It's a default that hasn't yet occurred. How can they cure that? Where do you get the legal right to put that requirement in a cure letter based on your contract? Not on good business, not on logic. I understand your position. Mine is, you wrote the contract. Are you asking us to rewrite the contract for you? Because now you're saying in your letter, together with payments which may subsequently accrue, paragraph 22 says you're curing your default, which means you've already breached. And we're giving you this notice because we have to give it to you before we accelerate.
Correct. But the note and the mortgage require that the payment be made each month. Here, the borrower is already, they are already in default. They are already in default. So the letter is required here, there's already been a default, and to not inform the borrower that they would be required to pay this payment, they might think, I only have to pay $83,000 as
Not
of,
advising you that you have to make a payment. You're instructing them that they have to make that payment in order to cure a pre-existing default in your letter. Your letter says to cure this default, prior conduct, you must pay the amount required
together with payments which may subsequently accrue. So in other words, to cure your past default, your past breach, you have to stay in compliance and make these payments. We can enforce it as part of our compliance to notify you of your default before we accelerate.
Yes, Your Honor.
Does that contract allow you to make that a condition as part of your cure?
I do not believe
Or
that
do you
there's-
have to send another default when they breach the February payment?
I do not believe that you would need to send another notice of default when there has already been an uninterrupted default under the authority of
Isn't it correct what you
Milam.
would do is accelerate, require all your future payments then to be due, which may make the interesting case from the Supreme Court of Florida an interesting variation about whether or not you can reinstate, because if you accelerate all the payments, you say there's a finite amount due, then the accrual can't be a breach because you have accelerated, which is what your contract allows you to do. Isn't that in fact your remedy?
I'm not sure that I followed
Okay,
that,
you don't
Your
have to,
Honor.
but I'm taking your time, so let me give you your time because you answered my questions and I prohibited you from getting to your questions.
That's okay, Your Honor. We may have covered a lot of it. Here, I believe that opposing counsel talks a lot about the amounts not being readily ascertainable, but again, he does concede in his brief that normal monthly payments would be within the borrower's personal knowledge. And if you look at the paragraph 22 letter here, the breach letter, the first sentence begins, "The mortgage loan on your property is in default as a result of your failure to make payments as required by the note and the deed of trust or mortgage." As the letter continues, it refers to payments. So there's no indication in this letter that...
Yeah, and I know you're out of time, but I need to ask this question. If they make the payment on the 30th day, so it's after the next installment was due, if they make the payment of the $83,000 and change, is it your position today that that, in fact, would not cure the default because the next installment was due the 1st of February?
Under this letter, it suggests, or it states that if an...
I want to know your position on behalf of your client. If they pay the $83,000 and they don't pay the February 1st payment that has come due, have they cured the default?
Under this letter, I believe that if that payment became due February 1st and it was not paid, then they would not cure the default.
Thank you.
And again, opposing counsel talked a little bit about preservation. Here we have intervening law, we have Milam, and we have the cases that followed Milam that adopted the substantial compliance standard that wasn't available to the trial court or the parties at the time of the hearing. But the counsel did argue that this is a very good letter and that it goes through all the requirements of paragraph 22. She didn't know how much clearer the letter needed to be. I don't believe that we have a preservation issue, especially because of the intervening law. And again, you did ask me before about whether remand would be appropriate to apply the correct legal standard, because there could be other facts that could be adduced to show that perhaps the borrower did call and wasn't given the amount. But here you don't. If you look at the affidavit, those facts were not set forth by the borrower. They didn't say that they tried to call. And here we have an opposing affidavit saying that the bank complied with their requirement and that they sent the notice. So I think still as a matter of law, you could determine that this letter substantially complies. And I want to point out that my counsel mentioned the Midtown case and that a borrower should not have to go fishing for information. But if you look at Midtown involves compliance with a statute. It's not talking about a contractual provision which is reviewed for substantial compliance. So the two cases are factually distinct. And just to wrap up, under the case law that's available now that is specific and relevant to the language in this case, the law does mandate reversal. You have Milam in this district that discusses similar language that required the January payment that was not yet due, and the court said that that letter substantially complied. You have the two cases from the 3rd DCA, Garcia and Cadet, with very similar language, and you also have the Diaz case from the 5th District where the court said that there is nothing wrongful about informing a borrower that he or she must make their upcoming payment in order to avoid foreclosure. So given the available case law that is specific to this very language, it's not a new issue. We would ask that this court reverse and remand for further proceedings. Thank you, Your Honors.
Thank you.